We are live.
Good morning. This is Senate Judiciary, January 30th, 2024. Imagine we're almost at the end of the month of January, and we still haven't accomplished our goals yet. So, with that, we're going to start today on Proposition 4, the Declaration of Rights, Government for the People, Equality of Rights. And we're going to hear testimony from the lead sponsor, Senator Ginny Lyons of Chittenden Southeast. Senator Lyons, welcome.
Thank you for having me. Shall I start? Go ahead.
Please.
So for the record, Senator Ginny Lyons, Chittenden Southeast, and it's a pleasure to bring Proposition 4 here this morning. This particular constitutional amendment proposal has a long history. Some of you might remember, and others not, that in 2017 well, I'll even start before that. In the summer and fall of 2016, I had a group looking at equal rights amendment opportunities, knowing that the cultural environment in our country was changing, and that we had already, as a state, looked at the equal rights amendment for women. And it came to me that we also needed to consider other groups, racial, ethnic, and so on, that are included in the proposal before you. So I organized a group from fairly statewide, not a large group, maybe 25 or so people representing different organizations. And we talked about introducing an equal rights amendment. Unfortunately, 2017 was not a year for that to be considered. So rather than introduce an equal rights amendment, I did introduce, on behalf, many of us introduced a resolution with a variety of whereas clauses. And I'm happy to share that resolution with you. That asked the legislature in 2019 to consider an inclusive equal rights amendment. That did not go forward. We had other concerns during that session, and another proposal that we looked at, constitutional proposal. So now here we are, we're at the next opportunity to consider an inclusive equal rights amendment. And I've worked to improve that proposal in a way that brings forward an amendment to Article 7 in the Constitution rather than a separate constitutional amendment. So obviously, for me, historically, we know that the various specific groups have been discriminated against, and based on their race, ethnicity, gender identity, racial heritage, and so on, or disability. And that discrimination has resulted in some uneven economic, some social inequalities, leads to economic inequality, and increasingly costly social, legal, and ethical dilemmas that face us every day, and in particular in this room, and me in the health and welfare. So it seems rational to change the Constitution and to put a baseline in place to demonstrate equal treatment. Now, Article 7 obviously does say equal treatment, but it was written at a time when we didn't have some of the social groups in our country, or racial and ethnic discrimination that we see in our country today, and we know how quickly the culture can change. We've seen that from 2016 to 2020. We saw there was a radical change in expression of beliefs around individuals in our country and groups within the country. So what I'm proposing here is something that fits within our current. When this was proposed in 2017, the original resolution, and then in 2019, the original Inclusive Equal Rights Amendment. It was supported by Black Lives Matter. It was supported by the Native American Alliance. It was supported by the ACLU. It was supported by the Attorney General's office and others. So it was and it was also supported by the Commission on Women, that had been very key in, and others supportive of gender equality, have been very key when the original Equal Rights Amendment was proposed in the state of Vermont back in the 80s. So I won't go through the proposal with you, but because
That's Eric's job.
You've got Eric here to do that. But you know, it just seems to me, I went back through my old folders. I couldn't find one of my more important folders, but I do know that there were 24 states that currently have a similar provision within their constitution. They're separate provisions. In fact, if you, I didn't look, but maybe I'll look again and see if I can find. There was a court case a few years ago in Texas that relied on this provision to protect an immigrant who was being unfairly treated within the judicial system. So I think this doesn't grant any additional rights to any group or individual. It simply allows for a contemporary look at who we are as a society, and to guarantee the rights of those groups that have emerged over time and have demonstrated a need for equal treatment. I don't know if there's much more I can say than that, except I think this is something, I'm so pleased that you're actually taking it up. And we'll answer some of the questions that have come to me. You know, one of the questions that's come to me is, why would you exclude religion? And in talking with Ledge Counsel, I think it was Eric, correct me if I wasn't Eric, it was whoever drafted this particular one. Yeah. Thank you, Eric. The answer is that religion is clearly protected in our federal constitution. And whether we need to adapt our own constitution to that. And I think that's a discussion you all have to get into.
Well,
it's above my pay grade.
I appreciate that.
Yeah, no, you don't have to. You don't have to do anything you don't want to. But but I think the other groups that have been identified are clearly identifiable, and there are some that have already been protected within Article 7 by our Supreme Court. So, you know, we have same-sex marriage, and our recent, we have other recent court decisions. The other question that's been brought to my attention is, will this give these groups who are named explicitly in the Constitution greater rights than other members of society? And I look at this and I try to figure out who those other folks are. Race, ethnicity, sex, disability, sexual orientation, gender identity, gender expression, or national origin. But I think each person in Vermont could probably fit into those categories, either one or two or three or one category. So I'm not sure that we are raising any particular individual, race, or group above any other within that expression. That's it. And we did have some articles that supported. I know you do a lot of work in here on non-discrimination, particularly within judicial and public safety. And we know that there have been studies recently, as recently as within COVID, looking at different health outcomes for folks. So I think you have an opportunity really to help move this along, and I sincerely hope that you will take it up.
Thank you.
In earnest. Thank you. I don't want to take too much of your time.
I appreciate it, Senator Lyons. We'll keep in touch.
Okay, well, good. Good luck.
Thank you. The next witness is Eric Patrick, Legislative Counsel, is going to give us a brief overview of the proposition, and then we'll hear from several.
Hi, good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel. As Senator Steers said, here to do a quick walkthrough of proposal number 4 to amend the Constitution of the State of Vermont. As Senator Lyons indicated, this is a proposal to amend and actually add some language to Article 7 of Chapter 1 of the Vermont Constitution. As you might also have picked up from Senator Lyons' testimony, I didn't actually draft this. Comes from several years ago when Bryn Hare was still an attorney in our office. So any sort of questions about the original intent of the language or where particular words were why those words were chosen. Unfortunately, I'm not going to be able to answer those, but I think your witnesses probably will be able to provide you some testimony on that. But I can certainly direct the committee to the language itself. I'm not going to read the purpose language, although I certainly could, Senator Steers, if you wanted, but I'm probably going to go right to the
let's just go to the meat of the
yes, exactly.
heart of the matter.
Right, exactly. That is on page 2, and unfortunately constitutional amendments don't have line numbers, but it's roughly halfway down the page. You'll see a line that starts section 2. Section 2, Article 7 of Chapter 1 of the Vermont Constitution is amended to read, and then you have the title of Article 7 is the next line. And you'll see, you may recall so the existing constitutional language begins with that government is. Do you see that? That government is, comma, or ought to be instituted for the common benefit, protection, and security of the people, nation, or community, and not for the particular emolument or advantage of any single person, family, or set of persons, or only a part of that community. Now that is what's known as the Common Benefits Clause. That's the existing, essentially it's analogous to the federal Equal Protection Clause. So it's the state constitutional provision that provides for equal protection of the laws. And it's phrased in terms of benefits. So when the government provides benefits, and one group of people is excluded, say, from a particular benefit, another group of people is able to obtain that benefit, the government has to justify that. It can't just happen in and of itself without some kind of rationale from the government. The existing rationale for the Common Benefits Clause that the government has to show that this classification is reasonably necessary to accomplish the state's objectives. The committee probably remembers that was what was developed by the Baker v. State Vermont Supreme Court decision that led to the development of the establishment of civil unions by the legislature. And so that's a very well-known piece of language in the Constitution now, this Common Benefits Clause. So the proposal in Proposal 4 is to add some language to that. And you'll see that in the next clause that's underlined. Now, I mentioned...
Can I
yeah, please.
Just to play the devil's advocate for a second. If we already have the common benefits protection that's already been defined and led to the Baker decision, and I think other decisions as well, why do we need this language?
I think that's a policy decision for the legislature.
The Vermont Supreme Court has already decided that on the basis of sex, disability, etc. Senator Machine, you want to answer my question?
Okay. I think maybe expanding on it, Eric, if you could touch on the conversation or the topic related to litigation. If something is going to the Vermont Supreme Court versus the U.S. Supreme Court, how those pathways, how the language in our Constitution governs those pathways regarding where a lawsuit ends up, whether it's the Vermont Supreme Court or the U.S. Supreme Court, and how this language could affect it, because I do see it as more than just a symbolic change to our Constitution. So, and maybe Peter Teachout can go into that deeper later on. But
no,
if you have initial thoughts.
Absolutely. Yeah, it's a good point that aside from any substantive differences there might be between what's in the language and what may already be protected by the Common Benefits Clause, the fact that it is in the Vermont Constitution means that the final say as to how that language is interpreted will be by the Vermont Supreme Court. The federal courts and the United States Supreme Court don't have any jurisdiction to interpret state constitutional law. So one might think that including language that expands upon, provides more detail on the protections of the Vermont Constitution, and therefore would be interpreted by the Vermont Supreme Court having the last word, might more align with what one would want to see in Vermont, as opposed to deferring to the federal courts and the United States Constitution, because those interpretations will depend on the makeup of the United States Supreme Court, the composition of the justices on that court. Put it in the Vermont Constitution, then you can rely on the fact that the last word, so to speak, will be by a court in this state.
And if it's decided by a court in this state, then it wouldn't have to go to the US Supreme Court.
Yeah, it couldn't, in fact. They don't have the jurisdiction to interpret the state constitution, or at least the last word on that is here.
Thank you.
Yeah. And I would add as well that and I don't know the answer to this, and Professor Ticho, I'm sure will have some more to offer. But as I was mentioning initially, that the common benefits clause that you have in the existing Article 7 is interpreted, the court has developed a manner to interpret state laws that say give benefits to one group of people but not benefits to the other. And that manner is, as I was mentioning, that the law has to be reasonably necessary to accomplish the state's objectives, or reasonable and just in relation to the governmental purpose. Adding these particular classifications, that if it's providing specifically that the government shall not deny equal treatment and respect under the law on account of a person's, and then as Senator Lyons already went through the classifications, that may lead to a more heightened level of scrutiny by the Vermont Supreme Court for laws that affect somebody because of their belonging to one of these classifications. So it's possible, for example, what is sometimes referred to as strict scrutiny under federal law, this very, very high level, this high standard of review that courts use, perhaps because of the specification here and the language used, that could result in a greater protection, in the sense that the court might apply a more strict standard of review for classifications that impacted somebody's belonging in one of those classes.
Can I ask a question about the purpose? We skipped over it, and I appreciate that. But
sure.
On page 2, the last sentence of the first paragraph, the proposed constitutional amendment is not intended to limit the scope of rights or protections afforded by any other provision.
Right.
Other than the Constitution. So that would include everything else, right?
Yep.
So it doesn't limit it, it just expands.
Correct.
Am I correct in viewing it that way?
Yes. So it wouldn't go, if the existing rights are a floor, these wouldn't go below that floor, but it could go above.
So I think that's an important, whatever right you have under Article 1, for example, of the Vermont Constitution, this doesn't restrict those rights, it expands those rights.
Exactly.
Thank you.
Yeah, absolutely. One other thing I would add is that.
I thought I was.
Yeah.
Took my Prevagen.
One last point I would add is that, as I mentioned, there's a federal equal protection clause. It's analogous. That speaks generally that government cannot deny persons equal protection of the laws. That speaks generally without specifying particular classes, the same way that the existing common benefits clause does. It just speaks generally about government not being able to deny common benefits to people. But as Senator Lyons kind of was getting at, there are other state constitutions in the neighborhood of 25, and many of them do have language similar to what is proposed to be added here, that in addition to sort of general requirements that the government has to treat people equally, under equal protection concept. For example, I just pulled a few out. There's, for example, Connecticut, no person shall be denied equal protection of the law or subject to segregation because of religion, race, color, ancestry, national origin, sex, or physical or mental disability. New Hampshire, equality of rights under the law shall not be denied or abridged by the state on account of race, creed, color, sex, or national origin. So there are a number of other states that have similar types of provisions that identify classifications of persons and say that with respect to, in addition to the general equal protection concept, states in particular can't deny government benefits on the basis of whether someone belongs to one of those identified classes of people.
Are there other questions for?
Just a quick one out of those 5 there that you mentioned. I see Connecticut had religion in there. What were the other 4?
These happens to be ones. Connecticut did have, Connecticut did have religion. New Hampshire was race, creed, color, sex, or national origin. Massachusetts had sex, race, color, creed, national origin. Arizona, race, sex, color, ethnicity, or national origin. Michigan, race, sex, color, ethnicity, national origin. But there are others. I didn't put there's in the neighborhood of 20, so I didn't.
There's a long
list all of them.
history, of, particularly in the early 1900s, of discrimination against certain religions in Massachusetts and even in Vermont. It would be, I'm saving that for Professor Teachout. I'd like to understand what we did there. Thank you.
Yeah, sure.
I think I understand it a little better now. Does the purpose go into the constitutional? No, I know it doesn't go into the amendment on the ballot. Does the purpose go on the ballot? You know?
I don't know. That's an excellent question.
I don't think it does.
All right.
Yeah, I'm wondering if people would.
If people are similarly not gonna quite know what it means.
Yeah.
Yeah.
I'll follow up in our office just to
Would you
be sure. Yeah, that's a good question. Yeah.
I don't remember the last time. So, I know the purpose doesn't go into the Constitution.
Correct. Right. But whether it's on the ballot, I'm not sure.
All right, good. Our next witness is Mark Hughes. Happy New Year, Mark.
Somebody's keys are here.
Welcome back.
There's yours, Papa.
Thank you.
You might need that sometime.
Hey, Mark.
Good morning. I am Reverend Mark Hughes. I'm the Executive Director of Vermont Racial Justice Alliance. I am minister at New Alpha Missionary Baptist Church. I'm the commander of the Veterans of Foreign Wars Post 782 Howard Plant in Burlington, Vermont. And I'm also the co-chair of the Health Equity Advisory Commission. Thank you for having me into your committee, Mr. Chairman. What I'll do is I'll cover some of this as it relates to racial justice and equity. And I'll also, I'll spend some time talking about a little bit about the law. I've been educated extensively by Professor Teachout. We were speaking just yesterday, but we'll leave the law to him. But I'll talk a little bit about it though, because there are some things that I think need to raise to the surface. I think sometimes it just requires a little bit more of a nuanced approach to the conversation if we're talking about the historical references as it pertains to our history of racial justice and equity and how the 14th Amendment actually ties in. So, Mr. Chair and committee, I believe this is my first meeting here with you post-COVID. It's really a pleasure to be back in this room. Again, this is where, Mr. Chair, as you recalled, you started it all with the racial disparities in the criminal and juvenile justice system advisory panel, where much of the work of Vermont going towards racial justice and equity began, and that was a result of a last minute Hail Mary that you threw in the spring of 2018. Thank you.
That was an interesting House Senate.
You were
We
not
voted on the bill while the House was on the floor voting on the bill.
You were not happy.
Well, they kind of screwed it up. We fixed it though.
We fixed it. So I would say, Mr. Chair, that there's little doubt that the Equal Protection Clause of the 14th Amendment of the United States Constitution was intended to stop states from discriminating against Black people. Hard stop. That is why the 14th Amendment was created. I do apologize for being so disorganized. I've been suffering from an incredible migraine over the last 24 hours. So I was not able to really pull together the testimony in the manner in which I would have liked to present it to you. I'll do the best I can. And if there's gaps that I need to fill in, if you'd be kind enough to have me back, I'm happy to do that.
We can schedule you next week if you just wanna make your major points today and then make a more official statement next week, we can do that.
That would be great. I really appreciate that. We know that also in addition to the bestowing full citizenship on formerly enslaved persons as well as persons born in this country, the 14th Amendment guaranteed all or most all persons due process under the law as well as equal protection of the laws, and it also required all states to do so. It was accompanied by the 13th Amendment as well as the 15th Amendments, which respectively abolished slavery as well as guaranteed the right to vote. Collectively, these three amendments are known as the Reconstruction Amendments, and they serve as the foundation of the post-slavery United States between the years of 1865 and 1870 after the Civil War. It is imperative that we ground the constitutional amendment on equal protection in this as we move the conversation forward. During this time, the Civil Rights Act, this Civil Rights Act passed by Congress, most notably the Ku Klux Klan Act of 1871, which created a private right of action in Title 42, 1983. This statute still provides the primary cause to ensure that governments must honor all persons' civil rights. So this is the foundation. The Equal Protection Clause of the United States Constitution's 14th Amendment is the foundation of all civil rights laws. And from it emanates the protection of the rights to all protected categories. And started with the Civil Rights Act of 1871. Again, this is though it may seem to be minutia and tangential, I do think it's incredibly relevant. So I've just asked a little patience with me as I begin my testimony. The 14th Amendment, it has faced ferocious resistance from its inception. Through it, though it can be made, it can be attributed to the notable advancements of the Freedmen's Bureau, HBCUs, and other advancements. The nation was bitterly recalcitrant to the 14th Amendment and Reconstruction writ large, specifically the Equal Protection Clause. Numerous failures, judiciary decisions such as Slaughterhouse, the civil rights decisions, and the infamous Plessy versus Ferguson all but disabled the Equal Protection Clause, and it left blacks in the United States virtually unprotected until Brown versus the Board of Education in 1954. The reason why this is relevant is because it was then and only then did we begin to start to create what we call basic analysis of the Equal Protection Clause, which was previously alluded to by your general counsel. The classifications as well as the levels of strict, help me out here, strict scrutiny, as well as those matters in which are more rudimentary, all developed as a result of the fact that there was a path that we got on during that time, moving forward, where jurisprudence rules the day. And right now, what we know is just over the last 50 years, there has been a proliferation within our court system, and even now a major supermajority on the United States Supreme Court. We know that there have been various decisions that have been handed down as of recent. We've seen Roe versus Wade overturned. We've seen the affirmative action case overturned as well. So what we know and understand is that there are a number of ways in which the civil liberties or civil rights, not just of Black folks, but also of other protected categories, are on a trajectory and at a velocity which is rapid of deteriorating currently. So it makes a lot of sense for us, you know, in the same manner in which the federal government stepped in to protect the civil liberties of citizens back during the civil rights era. Now more than ever, it's time that the states step in and create a backstop for citizens of the state of Vermont during this period. We've proven it to be effective for PR5 over the last constitutional amendment cycle. That was the reproduction rights for women. We saw that coming a long ways off. And we responded to it first statutorily and then constitutionally. In fact, the 13th Amendment of the Constitution of the United States prohibits slavery except for the punishment of a duly convicted crime. However, our last legislative session, our last constitutional cycle, we abolished slavery completely with no exceptions. So again, what we showed the United States on a federal level is that we were willing to exact, as Mr. Chair, you said earlier, there's a floor and there's a ceiling. We established a ceiling. It is more stringent in our state. The protections are more stringent in our states. Slavery is abolished, period. So these are examples of where we've already used our constitutional powers as a state to exceed that of the United States. I just want to back up a little bit and talk about, before we get into the impact of classifications and levels of scrutiny, and having a discussion about how that has created some of the challenges that we're currently endeavoring. I want to talk a little bit about some of the decisions that have been made historically, what I affectionately refer to as white affirmative action. Indentured servant, that was the African Slave Exchange. The 1719 Naturalization Act, that was the Free White Persons Act. The 1830 Indian Removal Act, that enabled white settlement. The 1862 Homestead Act that gave 270 million acres of land to white people. Alien and land laws, immigration restrictions, racial barriers to naturalized U.S. citizens, white racial preferences in immigration, reneged follow through on reparations, Monterey compensation paid to slaveholders, Jim Crow laws, the New Deal, Social Security, the Wagner Act, the Federal Housing Administration Exclusionary Loan Eligibility Act, otherwise known as redlining, the federal subsidies for suburban neighborhoods, transportation projects connecting suburbs through black neighborhoods, and the list goes on and on. So we know that to a certain degree, the middle class was established by federal programs and federal economic assistance, and wealth was actually developed as a result of it as well. I'm going to go off script. So I think that...
What was the Wagner Act? I mean, that's one I don't remember.
It permitted a non-white exclusion. There's a lawyer in the room. Are you familiar with it?
The Wagner Act. I just was curious.
So
I trust it wasn't positive.
it wasn't very good.
I hadn't heard of that.
So
I know, wasn't he mayor of New York?
we could talk about the war on drugs or the
Anyway,
war on
it doesn't
activism.
really matter, Mark. I'm sorry for throwing you off track.
No, that's fine. You're very good at that, Mr. Chair. We could talk about the war on drugs and the war on activism and the war on commissions, or I should say the failure to respond to the war on commission, and the list goes on and on. But what we see now is that programs and policies that are currently being implemented across the United States are at risk, and we do see that there have been programs and policies that have come through ARPA, like the FDA and the USDA's assistance program to Black farmers, understanding there was a tremendous amount of harm that was done to Black farmers over the last several decades. But yet and still, it was challenged constitutionally with the 14th Amendment, with the Equal Protection Clause, with a so-called reverse discrimination, if you will, allegation. And so there are many of these that are currently held up. I would say that that is one reason, and I have three, maybe four, that a constitutional amendment is important. I think just to step back from the conversation and just to think this thing through, what we know is that federal money has strings, period. Federal money has strings. And so when you talk about federal funding, federal programs, you start talking about initiatives, activities, there's going to always be there's going to be a requirement that the federal government is going to have, and there's going to be an authority that they have to step in and dictate the rules as far as this discrimination rules that we're talking about. And it's nuanced the way that it's done, and we can talk more about that later. I think Professor Teachout has a huge presentation for you this afternoon, so I think when we start talking about the law, again, like I said, I'll leave it to him. But the thing about the state is, you know, when it comes to our laws, when it comes to our money, when it comes to our programs, our priorities, when it comes to those things that we think are important for us as a state, then our Constitution prevails. And so I think that's why this is really important, because when we're doing things that are related to addressing inequities, and we are attempting to roll out programs and services across the state, then if it's dictated, if it's governed by, if it's funded by by the state of Vermont, and all of the other criteria that I just the aforementioned apply, then we don't have, at least we don't there's no concern about the risk of these things applying as far as the what we now see as the programs and policies that could be in jeopardy. Mr. Chair, I would ask that during your deliberations that you would ask your council to proofread you a list of those policies and programs or activities emerging, those that have failed the litmus test in Ledge Council and were not advanced, those that were introduced and are currently perhaps on various committees' walls, those that have been passed and are currently in implementation. For example, the Land Access Opportunity Board or the Health Equity Advisory Commission. And I would ask that this committee contemplate a thorough examination as to the implications of the federal policy and the status or the nature of these particular policies and programs had they been solely subject to state policy. And I think we will find an overwhelming and compelling reason why this constitutional amendment is important, and that it's necessary that we protect programs and our policies. One of the things that I would add to that is and what I'm holding here right now is the Sunrise Report for Land Access Opportunity Board, which has an extensive section on the Equal Protection Clause and the risks that it presents to this work and the challenges associated with navigating it, written by Attorney Robert Appel. There's a complete appendix in this report as well. I'll submit it to you. It is on legislative record currently.
Thank you.
The second thing that the reason I would say is super important for this constitutional amendment, I hope I'm doing okay being off script and probably off time. I'll pause for a moment before I go to the second, though, because you know me, I have a tendency of, well, you know me. Mr. Chair, if you have any questions.
I don't have any questions at this point. I wanna, before you finish, I wanna ask you about discrimination based on religion in your experience as a reverend minister? I forgot the church name,
We can-
Burlington.
If it's okay for us to come back to that?
Yeah,
Thank you.
that's the only question I have at this point. You've been pretty thorough. I think you're doing pretty well for stretching it together.
If you only knew. Any other questions from other members of the committee? So kind. The second area would be emerging challenges. So we've covered the policies as they exist, but we also understand that currently there are protections that are in place. One would be, say, for example, Loving. The decision on Loving with that, I know it sounds absurd that they would withdraw the right for interracial marriage, but it doesn't seem any more absurd that they would withdraw the right for autonomy, for reproductive autonomy. But I use Loving as an example, just as one example, and I could go on. But if our Constitution is protecting these rights, if it is explicit, and that is incredibly important, if there's nothing more important in these deliberations, I would hope that what we do is explicit, that it's very emphatic, it's incredibly specific, that it stresses the intent of exactly what it is that we're trying to do and why it is we're trying to do it. And I will just leave here as a placeholder for Ledge Council, maybe more homework, is I would consider going back and pulling the 2019 version of PR 4. Professor Teachout agrees. The 2019 version of PR 4 is also ironically equal protection. However, it attempts to add an additional article as opposed to modify the language in Article 7. I know that the original sponsor, Senator Lyons, did tell you that there was some attempt to modify Article 7. However, I think those of us who know about constitutions, and I would just digress for a moment and remind the committee, but that it was us who introduced PR2, the constitutional amendment to abolish slavery. That is what led us to this work, because the Article 1 of the Constitution has language, when augmented with Article 7, does serve as an analog to equal protection. It is not equal protection. I can't speak legally on this, but what I can say is from everything that we know, there's no specificity that this is indeed equal protection. And the language that's being amended into this Constitution goes towards moving us in that direction. However, if we were to insert an article specifically for this intent, and that with that particular intent, in my humble opinion, being to provide those protections necessary for those folks who are marginalized in our state, and to ensure that these marginalized categories, that we have the tools, that we are able, and this is very important, that we are able and have the tools to produce corrective policy to address the disparities that exist. Those are the types of things that need to be in that language. When you go and when your Ledge Council goes and retrieves that PR 4 2019, you will see that language in that particular.
I just asked Ledge Council to provide us with copies of that, and I believe Professor Teachout is going to suggest that he do that.
So we want to be on record as supporting that. So again, emerging federal challenges, we have no idea. We know that the decision on University of North Carolina, Chapel Hill, as well as Harvard University on affirmative action, completely withdrawing race as any criteria for selection in schools, has a much more far-reaching impact than any of us have really been able to get our arms around. This includes law schools. The other thing about this, though, is that there's a broader implication, because what it lays at risk is anything relating to any program relating to diversity, equity, inclusion, not just in any college, but in any organization, any governmental entity, or at any level across any state or federal government. So there is a tremendous amount of risk that we're under. And that, notwithstanding that, we also know and understand, in as much as we would like to think jurisprudence is not political, jurisprudence is political. And what we know is that the court system has been conservatively packed from top to bottom to include the supermajority on the United States Supreme Court. So the forecast is not good for us. So the whole idea of the emerging federal challenges that exist for us, particularly in light of the prospect of a conservative executive or commander-in-chief next year, I think is ample reason why we should backstop what we're doing with our Constitution and do the right thing. And then finally, the third thing is expanding on protections to other classifications. Now, when we talk about expanding on protections to other classifications, what we know is that there are some classifications that are just not protected as well as others. And what we'll see is, if we take a look at the city of Claiborne versus Claiborne Living Center, a case that was settled in 1985, is one of the very, very few examples where we see that those with disabilities were actually protected by the Equal Protection Clause. There are no others. So as a state, this gives us the ability to expand to our brothers and sisters with disabilities. So we've talked about race. There are many, many other classifications that could potentially suffer as it pertains to emerging federal challenges. To include the LGBTQIA community, we've got to protect our brothers and sisters there. To include the disabilities community, and the list goes on, our women, we need to protect them. We need to double down on everything that we can do to include the protection of every vulnerable category. And Mr. Chair, respectfully, that's everybody that's not a white cis man. So that third category, that challenge and that expansion there, I think is vital in the rationale and in justification of why it is that we would seek to amend the Constitution. I want to just conclude by telling you that there is, as you've said, there are dozens of states who've done this. The number is closer to 28, and you'll hear more from
Ben, could you ask them to quiet down?
Thank you.
You'll hear more on that later, but there's dozens of states.
That's not an equal right.
That's not an equal right. There comes a matter, I think the biggest issue that, I wouldn't say issue, but I think that one of the largest considerations, I believe, personally, and this is biased from the perspective of a racial justice activist, is that when we talk about because we've got to have a conversation about the governmental intent of the work that we're doing. And to your point, Mr. Chair, the justification or the legislative intent is not on the ballot. It is not. And if you pull PR2, the original PR2 as introduced in 2019, you will see language in our justification that goes directly towards, and the language says, this will go towards addressing systemic racism. Those are the words that we use. And we've used the term systemic racism a lot, in fact. There have been, when I opened this testimony, I spoke to you for a moment about where we started with Act 54 in 2017, and I thanked you for that. The sister part or the companion part of that bill was the Attorney General's and the Human Rights Commission's report on racial disparities across all systems of state government. And from there began the creation of the Office of Racial Equity. The following year, the policy. Ominously, in that enabling statute, Act 3, Title 3 to 5003 or something like that, specifically, the charge of that office is to eradicate systemic racism. So as we move forward and we look at the joint resolution, which everyone in this table was involved in, which is R113, the racism is a public health emergency. There's a commitment in that joint resolution, that joint legislative resolution to, quote, eradicate systemic racism. When we look at multiple policies that have emerged over the last several years, we keep coming back to this language, whether it is the executive order of the current governor, 0418, which sought to create the Office of Racial Equity with executive powers after the initial veto of the first iteration of that bill. Governor Scott, in the language of that executive order, which still stands today, says the purpose was to eradicate systemic racism. The Health Equity Advisory Commission, the Land Access Opportunity Board, Act 1. All of the work is headed towards that trajectory. There is a reparations bill on the wall in House General, in House General in Housing, something like that?
Military.
In Military Affairs.
I think military's moved to government operations over there now.
Oh, yeah. And I think my point is made, and my point is only that we are on a trajectory of addressing systemic racism as a state. Systemic racism, we've got, one thing that hasn't happened is that we haven't introduced a proper definition of systemic racism, and at some point I think we should.
I'd really like to get moving along.
Sure.
I've got other witnesses today.
I understand, Mr. Chair.
Senator Norris, you have a question?
Yes, I have to leave shortly here. I apologize for that and the rest of the witnesses, but I'd like you to hear respond to Senator Sears' original question in reference to the religion aspect of the Constitution.
What was the original question, sir?
What, religion is not included in this particular proposal, and my question was, as a reverend, your thoughts on that?
I did not notice that religion was not included in this particular proposal, and what I would do is I would punt on that one, kick it down the road to the attorney and allow him, Professor Teachout. I think what I see is no, it actually is. So what I have here is the 2019 proposal next to the 2023 proposal. And the 2019 proposal says that person's race, ethnicity, sex, religion, disability, sexual orientation, gender, identity, or national origin. The 2023 proposal says a person's race, ethnicity, sex, disability, sexual orientation, gender identity, gender expression, or natural origin. So it was included in the original one in 2019. It was excluded in 2023. I have no idea why.
Well,
So, Mr. Chair, I thank you for the time,
thank you for that.
and I would encourage the committee to take up I would encourage the committee to continue to take testimony on this. I would recommend members of the NAACP, the ACLU, Legal Aid, and others to come in and give some testimony.
What was the first group?
NAACP.
NAACP. ACLU, and,
Thank you for your time.
thank you. Appreciate it. Jay, do you want to say a few words on behalf of the Office of Racial Equity?
Yes, thank you very much. I'll take off my mask while I'm speaking so that folks who are online can also see my lips in case people need lip reading. For the record, my name is Jay Green. I use they, them pronouns. I'm the policy and research analyst for the Office of Racial Equity. Here speaking on behalf of the office on Proposal 4. First of all, thank you for the opportunity to provide testimony. At the risk of sort of a cliche of, beginning your essay with the definition of the word, I'd like to begin my testimony by reminding the committee of the enabling statute of the Office of Racial Equity, which is 3 VSA Section 5003. The Executive Director of Racial Equity, Director, shall work with agencies and departments to implement a program of continuing coordination and improvement of activities in state government in order to combat systemic racial disparities and measure progress towards fair and impartial governance.
I'm having a hard time hearing over the
I'll handle it.
people. No, that's fine. Let me do it.
Oh, kids. Oh, my God. Good luck. I'm glad.
I can't deal with it.
30 kids.
I appreciate that because I have trouble.
It's hard for me
Audio
too.
when
Yeah.
spoken words when there's background noise. Yeah.
Did you get it last?
Or they'll heard them elsewhere.
That'll last about 5 minutes, Jim.
Thank you, I'll do my best. So part of the Office of Racial Equity's enabling statute is overseeing a comprehensive organizational review to identify systemic racism in each of the 3 branches of state government and inventory systems in place that engender racial disparities. The reason that I bring this up is to say that our office supports Proposal 4 because it creates an explicit commitment in the state constitution to the work of dismantling systemic racism. That is the purpose of the Office of Racial Equity under statute. And I think that it's also very important in light of the June 2023 U.S. Supreme Court decision denying the federal constitutionality of race-based affirmative action programs. By passing Proposal 4, the Vermont state government is stepping up to protect Vermont or give Vermont residents the opportunity to vote on this proposal, which will protect Vermont residents in a way that reflects the recent decisions to create entities focused on equity, including the Office of Racial Equity and Division of Racial Justice Statistics. I also wanted to point out our support for the inclusion of other protected classes besides race and ethnicity, for example, because the term for sort of the combined experience of discrimination based on multiple protected classes was coined by Kimberly Crenshaw in her foundational 1989 paper as intersectionality. And that is the idea that people's experiences include a multitude of labels and categories. One person is not just their race or ethnicity, they are also their gender identity, their family ties. There's a lot of labels that we use to describe ourselves. So it's really important that this proposal acknowledges the importance of intersectionality and the fact that discrimination is more impactful the more ways that discrimination affects you, whether, if you are a person of color who also has a disability, who also is part of the LGBTQIA+ community, that's stacking layers of discrimination. So we emphatically support the inclusion of sex, disability, sexual orientation, gender identity, gender expression, and national origin in Proposal 4. I wanted to raise a brief question that I think Professor Ticha will speak to later about the appropriateness of modifying Article 7, the equality of treatment article, to include these classes. Because repairing historical harm sometimes requires equitable treatment, not equal treatment. And equity sometimes means targeting programs to populations based on need rather than absolutely equal treatment. And I will give my favorite example of equity versus equality, which is the idea of, like, say that you have a program that gives people free bicycles so they can get around their neighborhoods easier without cars. And the program gives everyone who comes there a adult-sized bicycle that is foot pedal powered. That's not going to work for a child who needs a child-sized bicycle. It's not going to work for an individual without the use of their legs who uses a wheelchair, who needs a hand-powered, arm-powered bicycle. So equity is when you give people the bicycles they need, not just giving them equal treatment by giving everyone the same size adult bicycle. It also speaks to that sometimes equity involves providing more resources because that arm-powered bicycle is probably going to be a little more expensive than the average adult bicycle. So that's my favorite example of equity versus equality. We urge the legislature to make sure that Proposal 4 is crafted to protect programs that are based on equitable treatment and not just equal treatment. And I think Professor Ticha can speak better to whether inserting these protections into Article 7 will do that adequately. I would, I know that Chair Sears raised the question of whether religion should be included. I think that is also a policy decision for the legislature to make. I would have to check in with my executive director, Susanna Davis, about what the office's official policy would be or official stance would be on the inclusion of religion. I can only speak from my personal viewpoint on this topic, but I question whether that is needed because there is adequate protection under I believe, the First Amendment of the United States Constitution for freedom of religion. And I have concerns with the tendency for some people to use the quote unquote freedom of religion as an excuse to deny the human rights of people like myself, transgender people, and other people who are members of the protected classes that are listed in Proposal 4. So that is my personal opinion. That is not the view of the Office of Official Equity.
Conundrum, because growing up in middle Massachusetts, there was a lot of discrimination on religious basis, particularly Jewish and Catholic, and Protestant. I mean, I went to school with all three, and we all got along, we played football together, did all things together, but there was a lot of discrimination. I remember that others who had different views, and I can remember going through my great-granduncle's things, and he was a photographer for Half Day News, which was a news company back in the day, like AP. And I remember seeing the Boston Globe, and wrapped in there, Irish Catholic need not apply for a job, for example. So, I mean, in the 1910s and 20s, you were advertising that in the Boston Globe. Think about today. So I think that's where my concern is coming from. Certainly don't want to say that because your religion says this, you can't bake a cake for a gay couple who's planning a wedding. I remember going through that 24 years ago during the Civil Union debate. Senator Rowski, did you have a comment? No, Senator Sheen.
I don't know that it's fully baked yet, so I might need another few minutes.
Okay, Senator Sheen.
Yeah, a few thoughts. Thank you for your testimony. I really appreciate it, and I agree with what you're saying. My first thoughts regarding the First Amendment. I mean, we've heard previously that there's concern about emerging federal issues related to these other qualifiers. And I do think there could be emerging federal issues when it comes to the First Amendment too. I mean, we really have no idea what the next 5 years is going to look like. And I think it was 6 or 7 years ago, we saw, I believe it was an executive order colloquially called the Muslim ban. And so I do think, and religion in general is a fundamental right. So, or the freedom to practice religion is a fundamental right. And so, I guess that's more of a comment as I'm mulling over all of this. And my other question is, certainly let's say if this passes as it's written, yes, it can have impacts in 3 to 4 years, but I'm also thinking about 50 to 100 years down the road. And, it's just looking at our Constitution, the seventh article was amended in 1994, and then before that, it was amended in 1793, and I'm sure they weren't thinking about sexual orientation or disability back then. And so I'm wondering if you have thoughts on, rather than having these qualifiers, we say all persons. That way, 100 years down the road, if there's something that we may not even comprehend as being an issue right now, does become a societal issue or a new protected class that we don't know about now, I'd want to make sure that those folks are also protected. So do you have any thoughts? So just to summarize, do you have any thoughts on the idea of, rather than having qualifiers, just having the words all persons for this?
Yeah, thank you for that question. I think my concern goes back to the definition of equity versus equality again, where we need the ability to focus on people who have experienced a history of considerable harm and discrimination at the hands of government and other social structures. And I think saying all persons doesn't give us that ability to finally tailor those programs to the people who have been most impacted historically. Yeah, I think your second point about the nature of social constructs and the fact that those are changing and evolving over time is a really good one. I think my response to that, and I've spent a couple of days thinking about this honestly, because I'm someone who finds the discussion of social constructs like race, gender, money is a social construct. I find that really philosophically fascinating. But I think my response would be that we need to act now to protect people. And then if those concepts change over time, then the legislature can make those policy decisions in the future to say, hey, we no longer consider this to be a valid description of certain people's experiences, so we're going to remove that. But for now, I think we need to act to protect the people who are here and use those labels.
Thank you.
Yeah, and actually, I'm sort of two minds on the religion question as well, because my family name was actually Greenberg, and it was changed to Green by my grandfather because he was having trouble finding a job in the after being a World War II veteran, having his education paid for by the GI Bill. He couldn't find a job in engineering because no one would hire a Jewish man named Greenberg, even though he was an Army veteran. So, yeah, it's the history of religious discrimination against Jewish folks is definitely not lost on me. But yeah, it's a complex
Yeah,
it's a complex
it
topic.
is a complex topic,
Yeah,
but it's
yeah.
certainly, I learned so much in 2000 when we did the civil unions, somewhat with marriage a few years later, but civil unions was a major change, obviously, for this state, and for the nation, and for the world. Quite frankly, had no idea it would have that impact, frankly. Wasn't that smart. But I remember the discussions, and we got down to it was, you're a justice of the peace, and if you're going to be a justice of the peace, you have to marry all people. And issue was if your church is a religious ceremony and you don't have to have the same rules. And there was an interesting debate that took weeks, really. But it shows how that, the right of in this particular case, was mainly the Catholic Church that was opposing, and they still opposed it, obviously, but it was the idea that, no, a priest is not required to perform a marriage. It's a religious ceremony. But if you're the justice of the peace, I don't care what your religion is, you're a civil servant, and you use it on that civil service. So, with that, can we get, is there any other questions for Jay? Jay, thank you, nice to meet you in person.
Thank you very
Thank
much.
Thank you.
And I think Big Hartman is on the Zoom. There they are. And then we'll get to Professor Teachout. Hi there.
Hi, can you hear me okay?
Yes, we can.
All right. Hi, thank you so much. For the record, this is Big Hartman. I am the Executive Director and General Counsel at the Vermont Human Rights Commission. I use they, them pronouns. I apologize, I'm not able to be there in person with you today. As you might be able to tell, I'm still working on healing from a cold and a cough. I didn't think you would appreciate me bringing that into your small conference room.
Not bringing it into the committee room, and you're coming through loud and clear. Thank you.
Okay, great. Well, I'm very grateful for the opportunity to testify regarding this important constitutional change. I will preface my testimony by saying I am not a constitutional expert. I did attend Vermont Law School over 20 years ago, and Professor Teachout was my constitutional law professor. So I'll defer to him on a lot of the constitutional questions you may have. But I want to share with you that the Vermont Human Rights Commission is a state agency. Our mission is to promote full civil and human rights in Vermont. We have broad enforcement authority to enforce Vermont's anti-discrimination protections in areas of housing, places of public accommodation, and state employment. Vermont does have very broad and expansive anti-discrimination protections that go above and beyond what is protected under federal law. And I think that reflects the legislative policy of, protecting as many people as we can with our statutes. When we look at the Vermont Constitution, it really is the foundation of all of our Vermont laws and our government action. It should absolutely contain equal protections explicitly and without relying on past interpretations of the Common Benefits Clause or other provisions of the Vermont Supreme Court. We know that Supreme Courts change, and interpretations or what we think is established precedent can shift, and it absolutely does over the years, over the decades, over the generations. When we solidify these rights in our Constitution, we help ensure that those rights will be protected throughout time, throughout changes in administration, and throughout Supreme Court appointments. I wanted to address some of the things that we've seen, that I've seen other folks touch on today. I was able to come across a very helpful resource about other states' equal protection amendments, which was created by the Brennan Center for Justice. And as of this year, and there have been a lot of updates in recent years, largely to respond to, I think, concerning case law out of the out of the US Supreme Court. So we now have 28 states in Vermont, 28 states in the United States that have some equal protection clauses in their state constitutions. And like I said, several of those have just come into play in recent years. These all protect people based on sex and gender, And about 18 of them also cover additional protected classes, like some of the additional categories that are being contemplated in Prop 4. So that includes race and color, religion, and national origin. I will say briefly, since it's come up in several other witnesses' testimony about religious protection under Vermont's Constitution, and I'll direct you to Article 3 of our state constitution, which addresses the freedom of religion, the right to practice religion, and it guarantees that no one's religious rights will be interfered with. And so I do feel that that area is very well explicitly protected and covered in in the current Constitution as it's written. And that's all the entire text. That's the entire purpose of Article 3 of our Constitution. What I found from that Brennan Center for Justice resource is that there's only one state in the country currently that has explicit protections in their constitution for the categories of sexual orientation, gender identity and expression, and disability and national origin. And so I really think that what we're looking at is on the cutting edge of advancing civil rights in the way that I believe is the intent of this statute. And so I strongly support that. And what I also appreciate about the section that's being added or proposed now is the addition of gender expression, I think, is really important, and I appreciate it. We know that folks are protected under state law based on sex and sexual orientation and gender identity. But we know that there are people whose gender identity may be very, let's say, straightforward, male or female, but their gender expression can still become a basis for discrimination. And so I really appreciate that someone thought to add that as an explicitly in this amendment, so that it is really confirming that protection for those individuals who may not express their gender in conventional or understandable ways to others. I think that adding these protections into the Vermont Constitution really sends a resounding and significant message that all people truly are protected by law and will be afforded equal rights. We do have good anti-discrimination statutes right now, but statutes can change, and as you all know, it's a harder thing to change the Constitution, so solidifying those rights under the U.S. Constitution, I think, has a lot of value. And I also had an opportunity to look back at the last Equal Rights Amendment that was considered. I think it was initially proposed in 2019, and it was called Prop 4 then as well. I appreciate it, and I think it makes the most logical sense to have the equal protections provisions in a separate section, a separate article of the Constitution, which was what was proposed last time around. I do kind of question why this would be in Article 7. Yes, there has been common benefits clause cases, so I get that. But that section article, that article itself in our Constitution, just like our statutes, the articles all have little subheadings. Article 7 subheading is government for the people. They may change it. So when you have an article with a heading that is explicitly stating what your intent is, I think that can be powerful. And that is what was done with the addition of Article 22 for reproductive liberty. The other thing that I prefer about the proposal from 2019, and I'm just going to read it for you in case you haven't gotten a chance to look at it yet. I think it was a more resounding statement. The first statement being that the people are guaranteed equal protection under the law, period. And then affirming that the state shall not deny equal treatment and respect under the law on account of a person's race, ethnicity, sex, religion, disability, sexual orientation, gender identity, or national origin. So since that language was originally drafted, this current version has that additional class of gender expression, and the category of religion was removed. There's an additional statement in the original proposal from 2019 that I think is really significant in light of recent constitutional case law from the US Constitution. And the additional language states, nothing in this article shall be interpreted or applied to prevent the adoption or implementation of measures intended to provide equality of treatment and opportunity for members of groups that have been historically subject to discrimination. And I think that that is really speaking directly to the equity programs, the equity work that we've already been doing for many years, and to confirm that the language in this Equal Protection Act would not is not intended to alter the equity work or to be used as like a sword against equity programs and equity, efforts throughout the state. So I think that is that summarizes the main things I wanted to say today. And I'm happy to answer any questions or come back in anytime that this committee has further information they may be looking for from the Human Rights Commission.
Yes, Senator Baruch.
Thank you, Big. I appreciate the testimony. Just a question to your first point about religion, because as you point out, it's been removed between 2019 and now. Given that Article 3, as you point out, covers religion, is there additional risk by putting it in this list of protected categories? I tend to have some of the same concerns that Senator Hashim voiced, that, I understand the concern about the Supreme Court's use of religion as a way to erode the rights of other categories, people in other categories. But I think there's a broad-based effort loose in the world to disenfranchise people, injure people based on their religion as well. So it doesn't necessarily sit well with me to try to make a statement protecting everyone, but say, well, in terms of religion, we're just going to remove it because we think there's a potential for abuse. Thoughts on that?
Yeah, I don't think there's no reason to object to religion being included in the list. But I think there's a reason to understand why it's not included, which is that there's already constitutional protections for religion that we don't see for these other categories that we're listing off.
Yeah. Okay. Thanks very much.
Thank you. Any further questions? Thank you very much, actually. We do appreciate you not coming by when you're...
Okay, great. Thank you so much.
Thank you. Can we hear from Professor Teachout if he's ready?
He is ready.
Good morning, Professor Teachout. Thank you for taking time out of your busy day to join us today.
Good morning, Chair Shears. I'm happy to be here. I hope I can be helpful.
We have copies of your testimony and we'd love to hear you.
Okay, would you like me to begin then? I apologize for joining the meeting late, but I just got out of class So I haven't
Feel
been.
fortunate that you were able to join us this morning, so please go right ahead.
Okay, so I haven't been party to the other testimony this morning, and I hope I won't be redundant. Please feel free to interrupt me if I'm covering ground that's already been well plowed. So my name's Peter Teachout. I'm a professor of constitutional law at Vermont Law School with a special interest in state and federal constitutional law issues. I testify from time to time before committees of the legislature on constitutional issues presented by bills that are being considered, and I've always considered a privilege, and I hope I can be helpful this morning. So I have submitted a copy of my written testimony. I will not read it. It's a little bit rough, and there's still footnotes to be filled in, but I make a couple of basic points in that testimony that I would like to summarize now. The first point is simply to explain why I think amending the Vermont Constitution to add an equal protection amendment is important. In the second part, I take a close look at PR 4 and the approach it takes to proposing that an amendment be added. I have some questions about that, and if time permits, I would be more than happy to share those questions with the committee. In doing so, I also suggest, for purposes of comparison, an alternative approach, because I think it helps illuminate what PR4 does and what it doesn't do. So if I could start then by simply explaining to the committee why I think amending the Vermont Constitution to add an equal protection clause is important. And there are two reasons. The primary reason is my understanding is the legislature in Vermont would like to have state constitutional support for adopting measures that implement the kinds of protections against discrimination that are identified in PR 6. I don't know if that's a problem, but it seems to me that that is a very important reason. That's one function that would be served by a constitutional amendment to provide state constitutional support for legislation that, for example, would deal with problems of what are called embedded racism to the extent they exist in the state, to provide state constitutional support for the adoption by the state legislature of measures aimed at protecting and expanding the protections against discrimination for those that are identified in PR 4. There's another possible reason, which is to somehow act as a bulwark against what's sometimes perceived as backsliding by the U.S. Supreme Court in terms of the protection of equal protection interests, and particularly somehow to provide some kind of response to recent Supreme Court decisions holding that affirmative action programs that take race into account violate the federal equal protection clause. As I will indicate later, I think we ought not to place too much hope on what a state equal protection amendment would do in that respect, but at least that was one of the justifications I've heard for doing so. My own view is that quite apart from those concerns, I think adding an equal protection clause to the Vermont Constitution is important for the simple reason that there isn't one in the Vermont Constitution right now. It's sometimes said that Article 7, which contains the so-called Common Benefits Clause, serves as an effective substitute for an equal protection clause. And the Vermont Supreme Court has from time to time had to make do with Article 7 as a kind of equal protection clause because of the absence of a real equal protection clause in the Constitution itself. But I spend some time in my written testimony documenting why I think Article 7 in the Common Benefits Clause does not provide an adequate substitute for a real equal protection clause. So that's my first point, and I'm happy to elaborate on that point if the committee would like. My second point was to look more closely at PR4 itself and note some of the questions, note what it does and what it doesn't do, and identify some of the questions I have about the approach that it takes. I don't know if it's worthwhile taking a look at the language, but basically, let me make 2 or 3 points about the approach adopted by PR4. First, you'll note that it takes the form of inserting the equal protection provision in an existing state constitutional article, that is Article 7. It puts it in as a kind of sandwiched middle part of what now is Article 7 of the Vermont Constitution. Second of all, it, by its terms, would prohibit discrimination by government, but it would not prohibit discrimination by non-governmental entities. I've taken a look at equal protection amendments and provisions in other states, and some of them do provide, in limited contexts, also prohibit discrimination against non-governmental entities as well as governmental entities. The other aspect of PR4 that I would like to point out is that the list of those categories of people that would be protected from discrimination is a finite list. And I'm troubled by that because constitutional provisions are supposed to last for ages to come. And what the consequence of that is, it would leave unprotected or potentially unprotected members of groups or classes that are not listed there. And I think it, at the very least, ought to have some provision for open-ended application and not be confined just to the list of the particular categories are listed there. And then finally, it's interesting if you compare the proposed PR4 amendment to the equal protection amendment in the 14th Amendment, it is limited to a particular kind of equal protection problem. That is, equal protection problems that take the form of discrimination against members of particular groups. But equal protection jurisprudence in the Supreme Court has had much broader impact, and it has been used, for example, to invalidate a whole set of laws that don't take the form of discrimination against members of a particular class or group. It's been used to strike down restrictions on access to vote. It's been used to strike down restrictions on access to the courts. It's been used to strike down measures that limit the ability of indigent people to participate effectively in aspects of the judicial process. It's been used to strike down provisions that deny access to welfare benefits and Medicare benefits and other necessities of life. So equal protection clause in the 14th Amendment has broader application than would the amendment that is proposed in PR4. So,
Can I ask a question or a comment? As someone who was in the I'm dating myself now, since I was here for both the Supreme Court cases using the Common Benefits Clause that resulted in Act 60, and the Baker decision that resulted in the Civil Unions Law of 2000. Your contention is that the Vermont Supreme Court bent over backwards to use the the common benefits clause, particularly on the issue of, the rights of, to marry.
That is true. I bent over backwards. It basically, since there is no equal protection clause, it had to make do with what it had to work with, which was the common benefit clause in Article 7. I have great admiration for the court's performance in Baker versus Carr, which is the same-sex union decision. But in that case, importantly, the court went out of its way to say Article 7 is not a provision that prohibits discrimination against racial minorities. I quote the court to that effect. It was never intended to be an anti-discrimination provision. It has another quite different purpose, which the court then went on to spell out. But in any event, the court itself said, look, this is not an equal protection provision. It's not intended to prevent discrimination against racial minorities. And then the court goes on to say, or to establish a mode of analysis for analyzing Article 7 challenges that is very, very different from the mode of analysis that courts use when they're analyzing equal protection problems. So there are just a couple of reasons why at least we ought to be reluctant to expect the court to use Article 7 as a full-blown, genuine equal protection.
I really appreciate that perspective, and frankly, at the time, I was only doing my best Harry Truman impersonation and saying, well, the Supreme Court's rule, we're gonna deal with it. But it was a stretch, I think. I remember in the Brigham case, spending a lot of time, I can't think of the attorney's name who did a lot of that work over in St. John's Ferry. I can't think of his name right now.
Bob Ginsburg.
Pardon me?
Bob Ginsburg.
Bob Ginsburg, yes. Spent a lot of time understanding how they arose to that decision. So it's really a very helpful professor detail. Senator Hashim has a question.
Thank you, Professor, for testifying today. I think I have two questions. I just wanted to revisit what you had mentioned about private actors, and I'm looking at the proposed language on page 5, which states in part, acting either alone or in conjunction with private actors. And I had previously thought that if a private actor is, I guess, sufficiently entangled with state government and providing services or whatever they might be doing, that the rules, that these types of rules would apply to them, or does it have to be spelled out in the language?
That's a very interesting question, Senator. There's a Supreme Court case that Jackson versus Metropolitan Electric, which involved a challenge to a utility tariff that was, in that case, it was the challenge was a due process challenge. But the question was your question, that is, would decisions by a utility be considered state action for constitutional purposes? And the United States Supreme Court, thanks to an attorney named Tom Debevoise, who represented the utilities, ended up deciding that utilities ought not to be considered state actors for purposes of the federal 14th Amendment. Now, I think it might make sense to provide, and that's why I suggested it in that proposed alternative to PR4, that we include a provision saying where government is sufficiently entangled with or involved with private actors, then decisions, for example, by utilities that affect everybody and have a profound impact on their lives, maybe ought to be considered under Vermont law as a form of state action that could be covered by the anti-discrimination provisions in the Equal Protection Act. So So I just thought it might make sense to make that explicit. And some states, in fact, do so. They say for certain kinds of relationships, sometimes housing, other relationships, private actors are covered by the anti-discrimination provisions of the state constitution.
Thank you. That clarifies it, and I appreciate that, and also agree. And I was also wondering if you could just touch on the effects of litigation. This was a question I brought up for Ledge Counsel at the beginning. If you could talk a bit more about when a case goes to the Vermont Supreme Court as opposed to when it goes to the US Supreme Court, and how that determination gets made, and how this language could affect that.
I wonder if you could pull that question into a little bit sharper focus by imagining or telling me what's the context in which you see a decision by the state Supreme Court and a decision by the US Supreme Court in conflict. The basic answer is under the Supremacy Clause, federal constitutional law trumps state constitutional law in every context, right? So in the abstract anyway, if there's a conflict, the US Supreme Court decision would trump the state decision. Now the way I think about it is, let's imagine a context. Suppose the state we adopted an equal protection amendment and the state adopted affirmative action measures in which race was considered, for example, as a factor in deciding preferences for university admission or for scholarship or even for clerkships with a state court. Now, it's possible the Vermont court would say that doesn't violate the state equal protection clause as written, although I think there are some questions about it. But that wouldn't, it seems to me, have any impact, because the federal law in that case, the court's decision in the recent Harvard and University of North Carolina cases, striking down affirmative action programs, say you can't take race into account. So in that case, the US Supreme Court decision would prevail over the Vermont Supreme Court decision. I don't know if that example helps at all, but that's the way I think of it.
Thank you. Yeah. And I think, and my apologies for not being as clear. I think what I'm trying to get more at is, I believe it's more appellate review. So if something is decided in Vermont and trying to figure out if the Supreme Court is going to hear it or not, and how it's determined whether or not it stays in Vermont rather than going to the US Supreme Court.
Whoa. Do that one more time.
Maybe I'll do some more offline research and send you. Thank you.
Please proceed, Professor.
Why don't we think for just a moment before we leave that, just think of another possible situation. And that is this. Suppose on the authority of the adopted equal protection clause in the state constitution, the legislature adopted a policy aimed at preventing or prohibiting discrimination against people because they have disabilities. Okay. Now, under federal constitutional law, discrimination based on disability is subject only to a rational basis standard of review. But if Vermont has its own equal protection clause, it's quite possible that the legislature would pass such legislation, or it could pass legislation discriminating against the disabled, and the Vermont Supreme Court might hold that's not true in Vermont. Under Vermont law, laws that discriminate against the disabled ought to be subject to a heightened standard of review, middle tier standard of review, or strict standard of review. In that case, there wouldn't be a conflict between the federal jurisprudence and the state jurisprudence, because the Supreme Court has clearly held that states can provide greater protections than those provided under the federal constitution. The federal constitution simply provides a floor below which state cannot go, but states, if they wish to, can provide greater constitutional protections than are provided under the federal constitution. So there's a great deal of latitude in adopting a state constitutional amendment for the state jurisprudence to provide greater protection to those categories of people than are provided under the federal constitution. I don't know if that makes any sense, but anyway, I throw it out there for what it's worth.
Professor, I'd like to refocus us in the final 15 minutes we have for you. I'm wondering if we could talk a little bit about the importance of a separate article over amending the
Okay, two things about that. One, I think including an equal protection in a separate article, an article of its own, taking the approach that was adopted with PR 5 and adding Article 22 to Chapter 1 of the Vermont Constitution. I think that gives to an amendment or to an equal protection provision, it underscores the kind of importance and independent significance of the amendment that doesn't occur if you sandwich the equal protection language in an existing article. So I think it does have that sort of impact. Maybe not a tremendous practical impact, but it does have that impact of underscoring the constitutional commitment involved.
That's all. I think I'm beginning to understand better why you believe that that's the right choice, and I'm beginning to agree with you that we should create a second amendment, excuse me, a separate amendment.
The reality is, in part, it's a political question. Maybe there was some thinking that if we sandwich it within, say, the language of Article 7, we can slip it by the public without it being sticking out in such a self-conscious way. But I think the real benefit would be having a separate article, Article 23. When we were first discussing this back in 2018, 2019, that was the idea, that we would include an equal protection provision as a separate article at the end of Chapter 1, rather than simply leading it in or weaving it into an existing provision.
What about the addition of religion? It was in the 2019 proposal, and it's not in this one.
What was the question, Senator Sheehan?
The addition of religion, or the in this particular proposal, the authors of it deleted religion from the protected categories. And I believe in the 2019 version, religion was included.
Well, that, boy, is a really interesting question. From a national perspective, you don't have to put religion in there because you've got a court that is looking for discrimination based on grounds of religion in every possible context. And we know that one of those contexts has to do with tuition support for private schools. But some state constitutions do include religion as a suspect category. So I don't have strong feelings about that. I noticed that age, which was at one point in time included in the list, discrimination based on age, has also been eliminated. So what does it mean when you sort of list the categories or classes that are going to be subject to a prohibition against discrimination? It doesn't mean anything in the abstract. In practice, it will depend on whether the court, in reviewing legislation, applies to that legislation that discriminates against one of those groups the same standard of review. It doesn't have to. It could apply a different standard of review for laws that discriminate. Let's see, if I look at that list, on the basis of, I don't know, national origin, than it does for laws that discriminate on the basis of gender or ethnicity. So that the decision about what standard of review to apply to laws that discriminate against one of those classes, members of those classes, is something that the court is going to have to decide upon as the cases are brought before it.
Interesting, thank you. Any other comments, questions for Professor Teachout? It's always good to hear from you, Professor, and we thank you so much for your time with us this morning.
Okay, thank you very much, Senator Sears. Let me know if I can be of help, and I invite members of the committee to review the.
Senator, has a comment or question.
Professor, I just wanted to overall thank you, not only for this testimony, but I know you've testified in other committees. We have a season where these come out, and in a certain way, we always look to you, and I know that eats into your schedule, but I just wanted to thank you on behalf of the Senate for being there for us.
Thank you very much, Senator Baruth. I appreciate very much your service as well. You've been doing good work. Okay.
Thank you very much, and we appreciate it. We will probably be calling again soon.
If I could make just one other closing point, in my proposed alternative, I include a provision that specifically authorizes the legislature to adopt measures, to adopt legislation implementing the provisions of the substantive provisions of the article. I think that's really important because that then says, look, this is not just a matter for judicial interpretation and application, but this is a measure that gives to the legislature both the authority and the responsibility for implementing the ideals, the vision, the substantive provisions that are contained here. I just think that it's important to include such an express authorization. You find it in Section 5 of the 14th Amendment and in the other civil rights amendments too. Thank you.
Thank you. Unusually, was your comment for?
Mr. Chair, if I could ask Professor Teachout one question. I know it's unusual.
Highly unusual, but I will allow it.
Thank you, I appreciate it. So, Professor, it's good to see you. And I'm wondering, is there, with the adoption of a constitutional amendment, a state constitutional amendment on equal protection, is the state required to relegate itself to the basic review standards that have existed for decades for federal equal protection? That is to say, the measures of classifications and strict scrutiny and so forth. Could the state not adopt their own method of review, given that our Constitution stands on its own with the equal protection clause?
Reverend Hughes, was that a question addressed to somebody?
I was asking you, sir. You're the only one in the room who can answer it.
In my screen, you were lost in a halo of warm light. And you're a little out of range of the mic, so it's a little bit difficult to hear you. But if you want to rephrase that question, I'd be glad to try to answer it. Okay. Oh, good.
Sure.
Now,
I'm sorry, Professor. What I was wondering is with the state adopting our own equal protection clause, does that automatically relegate us to the standing basic review processes that are relevant towards the existing equal protection clause of the 14th Amendment? Or
No,
would we be able to
no,
make our own?
that's a good question. Would the court have to employ the same mode of analysis, the same standards of review that the Supreme Court employs and that the federal courts employ in deciding equal protection cases? And the answer is no. It is possible that the court could develop its own mode of analysis for dealing with challenges under the state equal protection provision, but it's highly likely, following the pattern of other states, that it would follow that traditional pattern of analyzing challenges under the state equal protection. But it would be perfectly free to adopt different standards of review than have been applied by the United States Supreme Court in interpreting the anti-discrimination provisions of the Equal Protection Clause. So, same mode of analysis, likely different standards of review, quite possible. I suspect the Vermont court would take a harder look at discrimination against some of those classes than the Supreme Court is inclined to do under the Equal Protection Clause of the 14th Amendment.
Thank you again, Professor, and we're going to adjourn the meeting now. I appreciate all your time with us, as well as all the other witnesses.